Insurance companies hate these two magic words. Under the right circumstances, these two words will bring them to their knees and get them to settle your personal injury case. However, if your attorney abuses them or does not know how to apply them, they are nothing more than empty threats. My name is Phil Rizzuto from the Rizzuto Injury Firm. We represent clients injured throughout all 5 boroughs of New York City, all over Long Island, Westchester, and beyond. 2 words I'm talking about are bad faith. Insurance companies have an obligation to negotiate personal injury claims in good faith. Their failure to do so puts their own insureds at risk, and they can lose everything. Now, in every lawsuit, there are 3 elements which are required in order to be successful. These 3 elements are liability or neglect. Number 2, an injury caused by someone else's neglect. And 3, insurance coverage or a deep pocket that has the ability to pay for the injuries caused by the other person's neglect. The legal definition of negligence or neglect is the failure to use reasonable care. That is, if a reasonably prudent person fails to use reasonable care under the circumstances then and there existing at the time of the event, that is negligence. An injury means just that. It's an injury. It could be a physical injury, it could be a psychological injury, or it could be a financial injury. So, if there is a limited amount of insurance coverage and there is liability and damages caused by the neglect, then the insurance company better pay up, whether it's a $25,000 policy, a $100,000 policy, or more. In a nutshell, bad faith exists when an insurance company does not settle a case that it had the ability to settle, and they put their own insured's personal assets at risk, causing them to potentially lose everything. When that happens, now their insured, who has a judgment in excess of their policy limits, can lose everything. Now, when that happens, the insurance company is on the hook for the whole judgment plus interest at a rate of 9% per year. Now, just because the insurance company didn't settle the claim within the policy limits and there is a judgment in excess of the policy limits, that doesn't automatically mean you are going to win your bad faith claim. There are 7 elements that have to be met in order for someone to prevail on a bad faith claim against any insurance company. The first is the probability a jury will find in favor of the plaintiff and render a verdict in excess of the insurance policy limits. So let's break this down. Probability in this situation means it is more likely than not. In New York State, in a civil suit, in a case for personal injuries, a jury consists of 6 people that will render a decision. Their decision is called a verdict. So it is more likely than not that a jury will render a verdict in favor of the plaintiff. That is the person who was injured. That is the person who is bringing the lawsuit in excess of the insurance policy limits of the insured. The insured is the person who is being sued. That is the defendant. That is the person who the insurance company has an obligation to protect. In New York State, to operate a motor vehicle, the minimum amount of insurance coverage required is $25,000. Bad faith doesn't only apply to car accidents, it can apply to premises cases. But the reality is, in premises cases, the policy limits are often higher. And the higher the policy limits are, the more difficult it is to prove bad faith, because that gives the insurance company some leverage and some flexibility in order to negotiate. So if the policy limits are $10 million, well, the injuries have to be catastrophic and devastating and ruin a person's life in order to reach that limit. So it is unlikely that you will have a bad faith case if you have insurance policy limits of $10 million. But if the insurance policy limits are $25,000, $100,000, it is more likely that you can prevail on a bad faith lawsuit. Now, there are several factors that go into determining whether it is more likely than not that a verdict will exceed the policy limits. One of those things, as I mentioned earlier, is liability. Was the defendant negligent? Well, if it's a case where the defendant hit somebody in the rear, that is a very high probability. It's almost 100%. If it's a question of who had a red light and who had a green light, well, the probability may not be so high, depending on what the witnesses say and what the evidence shows. Now, another factor that needs to be evaluated separately when considering if it is more likely than not that a jury will render a verdict in excess of the policy limits are the injuries. The injuries are separately evaluated. One of the key factors is how old is the person, because the younger the person, the higher the likelihood it is that they will be awarded future damages, especially if the injuries are permanent. If the injuries are permanent, you could be compensated over the course of your life lifetime, for future pain and suffering, for future medical expenses, for future lost wages. All of that is taken into consideration. And if it is a young person, it is a high likelihood that the injuries will be significant. And if you have a minimum insurance policy, well, insurance companies have to take that into consideration when evaluating the case and the probability that a jury will render a verdict in excess of the insurance policy limits. Not only is future pain and suffering taken into consideration, but past pain and suffering. What happened in the accident? What was the treatment that they received? Did they sustain a fracture? Did they sustain soft tissue, neck and back injuries that they received treatment for and they received injections for? All of these factors have to be taken into consideration when evaluating the injuries and evaluating the damages and evaluating the likelihood that a verdict will be rendered in excess of the insurance policy limits. The second is lost opportunity, and that means when the insurance company fails to resolve a case when all serious doubts about their insured's liability have been removed. There is no clear-cut rule in a personal injury case when the insurance company loses the opportunity to settle a case. Many judges will interpret it many different ways. No two judges will interpret the lost opportunity at the same time, but there are many factors that will help in coming to that conclusion. One is there's a thing in litigation called summary judgment, which means either party can make a motion to have the judge determine whether there is liability or injuries or make a determination without a jury before the case goes to trial. If you are the plaintiff and you win a summary judgment motion on liability, meaning you've already determined the accident was the defendant's fault, that helps in proving lost opportunity to the insurance company. If your injuries are so catastrophic and a judge makes a determination that your injuries are related to the accident, especially in a car accident case in New York where you have to prove that there's a serious injury, if you already have that determination and you have liability determined, you can make a strong argument that once those determinations were made, the insurance company has lost an opportunity to settle the case. The third is when the insurance company's own investigation prevented them from making an informed decision about the risk of a potential verdict in excess of the insurance policy limits. The first thing an insurance company does when they get a new claim is they start to investigate. And one of the first things they will do is try to reach out to the plaintiff, the person who was injured, the person who will be bringing the claim against them, to get a statement. And one word of advice, never, ever, ever give a statement to an adverse insurance company. Get a lawyer. Lawyers work on a contingency fee basis, and it is your best interest to hire a lawyer before you ever speak to even your own insurance company. The fourth is they made no real attempts to resolve the case and protect their insured's interests during the course of litigation. Now, it is very sad to say, but in some cases, when we're trying to call the insurance company to resolve cases, there are some insurance companies you can't even get a claims adjuster on the phone. That's how bad it is. So in those cases, that element is very strong because they've made no attempts to resolve the case within the insured's policy limits. I have a case right now that's pending in Brooklyn that's on the trial calendar, and the insurance company has not reviewed the case. They have not called us back, and we are proceeding to trial. So that is a situation where they've made no attempt to resolve the case. There are other situations where you will speak to a claims adjuster and they will call you back, but they're nickel and diming you. They'll offer $5,000, $7,500, maybe even $10,000. And it's like Chinese water torture where they make settlement offers in very small increments with the hope you'll bite or your client will be desperate and want to take the money with the hope of settling the case. But they're not making a real attempt to resolve the case. And if you can show that, you're going to meet that element. Now, the fifth, they have to inform their insured that the plaintiff is willing to resolve the case within their insurance policy limits. They need to let them know what the current demand is and that they have the opportunity to get their own personal attorney to protect their interests, because the attorney that is representing the insured is usually hired by the insurance company. The insured also has the right to make a personal contribution to the settlement in order to make up the difference. This one is my favorite because it's the easiest to prove. The insurance companies know what they've told their underinsured. They should have notes in their system whether or not they told the insured of the plaintiff's settlement demand, of the plaintiff's desire to settle the case within their insurance policy limits. And they should have notes, they should have letters, they should have emails. When I was doing insurance defense work, I would always send a letter to my client, the defendant, who was the insured for the insurance company, the person being sued, telling them the plaintiff made a demand of X. The offer is Y. You have the right to retain your own personal attorney to protect your interests. Why? Because we are hired by the insurance company. I was always what is considered outside counsel, meaning we have no connection with the insurance company whatsoever. We do work for that insurance company, other insurance companies, other people. There is really no allegiance to that insurance company other than we want to do a good job and we want to keep the account. But we are completely independent. And one of the reasons we would get sent to work is the cases were bad. I got some pretty bad cases as a defense attorney to protect the insured's interests. But also my interest was in covering my ass and making sure that my clients were made very well aware of what the demand was, what the offer was, that they had the right to hire their own personal attorney, which nobody, I shouldn't say nobody, it happens. People actually do it to protect their interests, to put pressure on the insurance company to settle these cases. One of the other things I always do when I'm sending a bad faith letter to the insurance company, I tell them to keep documentation of their communication. Because when I start a bad faith action against them, I want to see what attempts that they've made to contact their insured. And more often than not, you're going to see it's nothing. The insurance companies think they are high and mighty, and they don't have to tell their insureds everything because they're going to take care of it. And when they fail, and when there's a bad faith claim, that is a great element, because you can show that they never, ever told the insured that the plaintiff was willing to resolve the case within their policy limits. And that is strong and powerful and will help you win your bad faith case. Now, this brings us to number 6. The insurance company has to weigh their risk to the insured against the financial benefit they will receive by trying to save some money off of the policy limits. Now, absent a bad faith claim, the insurance company's exposure is what the insurance policy limits are. So if the policy limits are $25,000, their exposure is $25,000. If their policy limits are $100,000 or $500,000 or $250,000, whatever it is, the insurance company's exposure is limited to the insurance policy limits. And that is one of the reasons why insurance companies will nickel and dime you on a personal injury case, because they sit back and they say, well, you know, what's the worst that's going to happen? I get hit for $100,000. But not if there's a bad faith claim. Their exposure is unlimited, and that's because the exposure to their insured is unlimited. Don't forget, the insured is the person who buys insurance from the insurance company to protect them in the event of a personal injury claim just like this, just like what we're talking about. And when the insurance company leaves them hanging out to dry, their exposure is potentially unlimited. They can lose their house. They can get their wages garnished. They can get their bank accounts garnished. So if you're an insured and you have assets, they are at risk when your insurance company puts their own financial benefit over yours. In my opinion, I think an insurance company is better off making no offer stating that we have a strong liability defense, we have a strong injury defense, rather than trying to save $25,000 or $15,000 or $10,000 or any money off of the insurance policy limits. Because once the insurance company makes an offer, they are acknowledging that there is exposure and there is a potential claim and verdict in excess of the policy limits. And by them not making a good faith attempt to resolve this case, they are leaving their insureds hanging out to dry and risk of losing everything they have worked their entire lives to get. Now, number 7 is a catch-all. Is there any other evidence that would tend to support or negate the insurance company's bad faith in refusing to settle the case? This cuts both ways and can also work to the insurance company's benefit, because the insurance company will make every claim under the sun not to pay on a valid claim. They will say that plaintiff didn't have injuries, and if they had injuries from this accident, they weren't related to the accident because they were pre-existing. If they were pre-existing and they were related to the accident, they healed and they got better, and so there are no future damages. They will come up with every excuse excuse they can think of not to pay. But other evidence that cut in favor of the plaintiff, person who's injured, who's bringing the lawsuit, is, the treatment. I've had continuous treatment from the time of the accident up until the time of trial. I've had invasive treatment. I've had injections. I've had psychological injuries from this claim. I'm not able to do the things I was able to do before the accident, or I'm able to do the things I was able to do before the accident, but I do them with pain, and I can't do them as well, and I can't do them as often. And a person's age, to me, is a big factor. If a person has surgery, it's a big factor. So these are all other elements that can be thrown into the pot when you're trying to make a bad faith claim, and the defenses that the insurance company will use. Let me tell you about two cases I was personally involved in. The plaintiff, Jesus Tavares, was a backseat passenger in a taxi cab that was involved in an accident with another taxi cab and another vehicle. As a result of the accident, he claimed to have sustained an exacerbation of a pre-existing back injury, which required surgery, as well as knee injuries, which required surgery. It was a 3-car accident where one cab hit another cab and hit a car in front of it. Front car got out, and liability was apportioned between the two cabs, 70%, 30%. Each cab had $100,000 in insurance coverage. An interesting footnote about this case is that the policy limits of $100,000 for each cab were tendered during the trial, but rejected by the plaintiff, and the court found that the tender of the policy limits was too little, too late. The plaintiff ended up obtaining a judgment of $9 million, which was reduced to $2.5 million on appeal. However, there was only $200,000 in available insurance coverage between the two taxi cabs that were insured by the same insurance company. After the verdict, the defendants assigned their bad faith claim to the plaintiff, Jesus Tavares, and he proceeded with a bad faith action against the insurance company. After years and years of litigation and appeals and more litigation, the case was settled. The insurance company ended up paying far in excess of the insurance policy limits of $200,000. This is a landmark historic case in New York because as a result, the 7 elements of bad faith that I talked about earlier were born. Now, in the second case, a woman slipped and fell on oil that existed in the roadway as a result of an oil company's spill of oil they were carrying. She sustained 2 fractured wrists. The insurance company conceded that the accident was their fault for causing the oil to be spilled in the roadway, but refused to settle the case within the insurance policy limits, which was only $50,000. The jury rendered a verdict in the mid-6-figure range, and a bad faith action was commenced. The insurance company eventually settled the case, paying very close to the judgment. When we have a situation when the insurance company is negotiating with us in bad faith, I prepare a letter, I go through all the 7 elements of bad faith, and I explain in each one how our case is applicable to each particular element. Now, by the end of the letter, I have specifically laid out my bad faith case, explaining why the insurance company should tender their policy limits. This works, but this only works when you use it appropriately. If you abuse it and you send a bad faith letter on every case where bad faith probably doesn't apply, you will lose credibility and the insurance company is not going to negotiate with you. But when you have a case that meets all 7 elements and you can show the insurance company how they negotiating in bad faith and you meet all 7 elements, they will tender their policy limits and settle the case because they do not want to face a bad faith lawsuit. If you or a loved one have been injured as a result of a car accident, slip and fall, trip and fall, cosmetic injury, nursing home neglect, funeral home neglect, product liability, construction accident, any type of injury that you have sustained through somebody else's negligence, ring Rizzuto at 800-666-5555. We can help. If you found this information helpful, hit the like button, subscribe to the channel, and follow for more. I'll see you next time.